Good afternoon, ladies and gentlemen. Welcome to the third webinar of the 2022 VIAC arbitration series, VAS. The 2022 VAS is held in complement to the establishment of VIAC, the Vietnam Institute for International Arbitration Research and Training, a division of VIAC, with the objective of leading the academic and specialized research on ADRs and providing quality and intensive skill training courses to encourage and promote the Vietnamese community of arbitration practitioners. In the first webinar, we discussed key criteria of arbitrators and legal counsels as demanded by the arbitration market. We then looked closer into the role, the function, and the duty of the arbitrator and the tribunal in the second webinar last week. To further understand the idea of the criteria of the arbitrators discussed at the first webinar. This week, I'd like to invite you to focus on a very interesting topic about a phenomenon that is quite common in a young jurisdiction with a relatively small arbitration community as Vietnam. Double hatting or dual hatting in arbitration is generally understood as the practice of one individual performing two different roles in arbitration cases simultaneously or within a short period of time. The terminology does not only refer to acting as an arbitrator and counsel simultaneously, but may also extend to other roles such as expert witness or mediator in separate arbitration proceeding. So this practice may raise a lot of questions concerning arbitrators' diligence, independence, and impartiality, as well as many other issues of role conflict when a person performing multiple and sometimes overlapping roles. So there have been debates on double hatting around the world and differing views concerning whether double hatting should be regulated, and if so, scope of such regulation. So at the first sight, one might have a positive first impression with double hatting. Negative first impression with double hatting due to some concerns. But it is only fair to believe that there's more of double hatting than just a frown. Therefore, today's webinars will focus on the topic, double hatting in arbitration, look at the both sides of the coin. I hope that we can fairly discuss both advantages and disadvantages of double hatting in arbitration practice. This webinar features VIAC listed arbitrator, Professor Kim Joongi, to be our keynote speaker. Professor Kim is currently the professor of law at the Yonsei Law School of the Yonsei University, one of the top 3 prestigious universities in Korea. And for your information, Korea is now one of the emerging arbitration jurisdictions in East Asia. Joining Professor Kim today in the panelists is Dr. Linh, who has participated in many international arbitration cases, both as a counsel and as an arbitrator, both in Vietnam and foreign jurisdictions. Together with Dr. Linh is our counsel, Ms. Đào Như Ngọc Linh, who has a very strong background in international dispute resolution and also an experienced counsel in managing cases at VIAC. So without further delay, may I ask Professor Kim to take the floor. Professor? Sorry, sir.
Thank you, Ms. Hong. It's a great pleasure to be here. I want to thank VIAC and VAS and VIART as well. I'm, of course, very impressed with the tremendous progress that's occurring in Vietnam. The sophistication and the growth is truly impressive. And of course, I welcome any comments and questions you might have over the next hour or two. We, of course, feel free to chat your questions or to ask questions at any time. So of course, we want to highlight some key issues for you and provide a general overview of the relevant issues in double hatting. And we'll hopefully have a lively and interesting debate during the session and at the end as well. Okay. So the first question we have, of course, is what is double hatting exactly? There actually is no kind of fixed or set definition. There's various definitions. As Ms. Hong suggested, some suggest it's role confusion. So you're confused about your role. Some suggest it, or it could be it could be more than double. It could be multiple role playing or hats that you have on. Now, one thing we want to focus on is whether we want to go for a kind of a narrower definition or a kind of a broader definition. Now, for the narrower definition, and this is kind of a more strict definition, it's one person at the same time or within a very close time span doing the same thing. So while they're acting as an arbitrator for a case, at the same time, they're also, usually the case is if you're very able, like Dr. Le, you're also acting as counsel. So you're doing both things at the same time. So that's kind of the probably the strictest definition of double hatting. So you're the same person, one hat as an arbitrator and one hat as counsel. So on Monday, you wear the arbitrator hat, and maybe later in the evening, you wear the counsel hat, and you go back and forth, but they're the same person. Now, of course, it's not only acting as arbitrator and counsel. You could also be an arbitrator on one day or in the morning. And the evening, you could be acting as an expert witness in an arbitration. So if you're like Dr. Le, one day you're an arbitrator, acting as an arbitrator, and in the evening or the next day, you're acting, for instance, as an expert witness on Vietnamese law, and you're testifying in front of a tribunal. So you're doing both things at the same time. Or you could also, as we'll see later, be an arbitrator and a mediator at the same time or within the same time span. So when one person is kind of doing both things at the same time, this is kind of probably the narrowest definition of double hatting. Now, the definition, of course, could be a little bit broader, and it could be not just one person strictly doing this and that, but it could also involve kind of broader relationships between the arbitrator and a counsel or even a party or expert witnesses. And that's kind of a looser, broader definition. And of course, this could get very, very broad, and then it kind of spills over into general definitions of general conflicts as well. So we will try to keep generally a more narrower definition, but keep in mind, it could be broader as well. And I'll try to explain, or we'll look at some possible scenarios where kind of the broader definition could be triggered as well. Okay, now, one interesting question we have to think about is, for double hatting, should we have a different standard depending on what type of arbitrator you are? So usually, of course, if you're a big arbitration, you have 3 arbitrators, and then there's the chair, and of course, you have the 2 party-appointed or wing arbitrators. Some suggest that the standard to apply to the chair, or of course, if you have only 1 arbitrator, sole arbitrator, should be maybe higher or stricter than if you are the wing arbitrator, the party-appointed arbitrator. Now, some, of course, suggest it should be the same, and the party-appointed arbitrator should be held to the same standard, and the party-appointed arbitrator should be just as neutral and unbiased and independent as the chair. Some, however, suggest that, yes, party-appointed arbitrators should be neutral and should be independent and impartial. But if there's kind of a gray area where it's not really clear, and even based on your own conscience and integrity, it's not clear. When you're in a really gray area, some suggest the party-appointed arbitrator should maybe try to highlight areas or arguments that are more beneficial to the party that appointed them. That's one view as well. And there's strong argument for that as well. So if that's the case, some would suggest maybe the standard for the party-appointed arbitrator should be different, or perhaps relatively a little bit lower. That's what some suggest. Now, for double hatting, of course, that leads to interesting questions. All right. All right. Now, for double hatting, like I said, I want to try to focus a bit more on the narrower definition. For double hatting, we'll assume that the person wearing 2 hats is dealing with a situation where there are not the same parties involved. Different parties are involved. And different issues are involved. If that's the case, then the question is the cases aren't related. But would the arbitrator potentially act, or when they're deciding, they might act consciously or even unconsciously for their own personal interest, for whatever that might be, or for a particular party's interest. And we'll get to some examples about this. Now, particularly if it's an unconscious thing, it's very difficult to measure. And even for the conscious thing, oops, recording stopped. Should I wait or should I continue? I will just continue because I haven't received any other word. Okay, so if it's an unconscious or conscious thing, then one wonders, and of course, we're not talking about the arbitrator being purposely favoring. Well, that's one concern, and we'll get to that, that consciously, if I divide this case this way, it's going to help me in another case when that similar situation arises. Is that going to occur while the arbitrator is deciding? This is the question. If it's not going to occur, then double hatting is not a serious issue. If it is, and there's a perception it is, then it can be an issue. Okay, The first thing we'll look at is in a kind of a commercial arbitration context. And then, of course, we'll look at it more in an investment arbitration context. Now, when we're talking about the commercial arbitration context, of course, a lot of the issues are going to overlap with investment arbitration, but there's some very specific differences between commercial and investment arbitration. But what I'm going to talk about now could apply in the investment context as well, but we'll just try to raise it in the commercial context. So the first thing is, of course, as you all know, you're all aware of the IBA rules of conflicts of interest. And IBA has particular guidelines on rules on how one should decide when you have potential conflicts of interest. And of course, in the IBA rules, you have a red list, an orange list, and of course, a green list. And I'm told, of course, that you're all well aware of this. So, first scenario. So you have a case involving potentially Venus, one party, is claimant, and Mars is the respondent. And arbitrator Tron has been appointed in this case as a member of the tribunal. Now, Mr. Tron or Mrs. Tron or Ms. Tron is also at the same time acting as counsel, expert witness, or mediator at the same or similar time in an unrelated case. Okay, so it's not related to Venus or Mars and not involving any of the parties. Okay, so in that case, I probably and that's double hatting, of course. Most of us would think that doesn't seem to raise much controversy. And this is very common and happens all the time. So arbitrator Tron is acting as an arbitrator in the Venus versus Mars case. And in the second case is actually as counsel, expert witness, or mediator. But they're unrelated and the parties are different. Now, in the second scenario, it's kind of a broader situation. It's not arbitrator Tron, but it's arbitrator Tron's colleague. And of course, many arbitrators are lawyers and they work at a law firm, and it's one of their partners or one of their associates, someone who works together with them at the law firm. And that person acts as a counsel, expert witness, or mediator, again, in an unrelated case not involving any of the parties. So this, I think most of us would think, not really a big problem. And you would say, what's the issue here? So, and that's probably where most people would stand. Now, it gets a little bit trickier when everything is the same, but in the second case, their issues are related. Okay, so in the Venus versus Mars case, there's an issue regarding, I don't know, liquidated damages. And in the second case, where arbitrator Tron is acting as an expert witness, again, he or she is testifying on liquidated damages in Vietnam. It's the same issue, a related issue. Now, this gets closer to perhaps a double heading issue that could be an issue some suggest. And this potentially, this could be what we call an issue conflict. So the issue is when arbitrator Tron is acting as an arbitrator and when arbitrator Tron is acting as an expert witness. So when the arbitrator Tron is acting as an expert witness and is testifying on liquidated damages, arbitrator Tron is going to say, in Vietnam, liquidated damages is a very specific thing, can only apply in circumstances A, B, and C. And they testify like that. Then is that going to influence arbitrator Tron when they're deciding the case Venus versus Mars? And are they going to think, oh, I testified that it's only A, B, and C before, then is it going to be only A, B, and C? Is that going to be influencing my opinion when I'm deciding in Venus versus Mars? Okay. And some suggest, no, arbitrator Tron is an arbitrator. When they're putting their arbitrator hat on, they're going to have an open mind, and sophisticated arbitrator Tron can distinguish between the two roles when they're an expert witness and when they're an arbitrator. That's not a big problem. Or arbitrator Ron's going to get confused. Oh, yesterday I was testifying it's only A, B, and C, and today I'm not sure. It's not clear. I'm getting confused. What I said yesterday and what I said today. So this is a concern. This is a concern. Okay, now this is even a bit more complicated situation. All right, I'm going to try to walk through this slowly, but I mean, of course, there are many, many scenarios that can occur, but I put together this scenario. All right, so let's think about this. So you have a case between two parties. Saturn is the claimant, and you have Pluto as the respondent. And you have a lawyer, Vu, is the chair of the tribunal. And then you have Tron, or Tron's colleague, is acting as counsel, lawyer, for Saturn in the first case, Saturn versus Pluto. All right. Then you have a second case, unrelated case. And this is Venus versus Mars. Totally different parties. And to make it simple, totally different subject matter. Now, in the second case, lawyer Vu, same person, is acting as a lawyer for Venus. Okay? Now, at that situation, in the second case, the claimant Venus has to appoint an arbitrator. All right? And they decide to appoint, of all the people in the world, they decide to appoint Tron, who is acting as counsel in the first case for Saturn. Okay, everybody follow that? So the question here is, can the second case where arbitrator Tron is being appointed as a party appointed arbitrator in the Venus versus Mars case, Venus versus Mars case. So arbitrator Tron is wearing two hats, right? In the first case, arbitrator Tron is counsel. And in the second case, arbitrator Tron is being appointed as an arbitrator. But can arbitrator Tron's appointment in the second case be challenged? Is this a conflict because of the double hatting? Is the question. Okay, again, unrelated parties, unrelated issues. Okay, So it's a complicated, but these types of scenarios, and of course, well, I'm sure we'll hear from Dr. Lu, and I'm sure you in Hanoi and Ho Chi Minh and Da Nang and all over Vietnam, where you have a small circle of people who have expertise in international, particularly in international arbitration. These types of situations come up all the time. And it's not necessarily because lawyer Vu wants something, is trying to manipulate the system. Maybe arbitrator Vu thinks Mr. and Mrs. Tron is a really good arbitrator and a really good lawyer. So that's why they want to appoint arbitrator Tron. Now the concern, what are the concerns? So you can think of many concerns. And the concern, of course, would be that when arbitrator Tron is appointed in the second case, Venus versus Mars, is arbitrator Tron really going to be independent and impartial? And of course, perceived as being independent and impartial. Perception is, of course, very important. Or is arbitrator Tron going to be somehow influenced by the fact of Mr. Lawyer Vu's relation? But the only relation here is that Lawyer Vu is acting as chair in the other case. So the connection is not so direct and not so clear, but some might argue that when Lawyer Vu was appointed as chair in the first case, Mr. Tron or Mrs. Tron, Ms. Tron, approved that. They didn't object. And of course, if they were involved in the process of appointing Lawyer Vu in the first case, then one might think that Mr. or Mrs. Vu, Lawyer Vu, feels maybe a little debt or gratitude toward arbitrator Tron or something like that. And in return, Lawyer Vu is appointing Tron as an arbitrator in the second case. And as a result, Tron will also feel a debt of gratitude or gratefulness for being appointed arbitrator in the second case. Or, of course, arbitrator Tron is like, I'm so busy. Why did this guy appoint me? There could be many scenarios. Now, that, of course, would assume that Lawyer Vu in the first case was appointed with party approval. Of course, if the Lawyer Vu in the first case was appointed by the institution, a lot of that would be much less likely, all this concern. So this is a scenario, potentially. And of course, a lot of this, of course, can be resolved, of course, under the IBA rules and other things. Ideally, when Tron is being appointed for the second case, they would disclose. But of course, how far do they disclose? The fact that they were acting as counsel in a case where the Lawyer Vu was chair of a tribunal. And of course, this would be disclosed. And if parties don't raise an issue, then of course, that's a different. But whether this could be challenged or not, and the similar scenario, there is a similar scenario where this occurred. And in that case, I think it was the tribunal decided that there were not sufficient grounds to challenge the arbitrator. Okay, like I said, there are many possible scenarios, and this is just one. All right. We're getting some interesting questions. Okay, let's see if I can pick up on any of these questions. Yeah, I think lawyer acts as counsel in the case with really, but he might not know the other two members that he could form a pre. Yes, of course. In the second case, it's going to be, like I said, remember when I said earlier, it's going to be different depending upon whether Tron is going to be a party appointed arbitrator as opposed to being the chair. And yes, it's a fair point. who are going to be, if they're a 3-member tribunal, who are going to be the other 2 arbitrators? And, that mix could also influence the process. Okay, let's move on. All right, now, this is another scenario that I've come up with, and it's like a similar scenario has occurred. So arbitrator Tron is appointed as an arbitrator by the respondent. And of course, usually it's going to be the law firm representing the respondent. In this case, it's the law firm Hanoi that has appointed arbitrator Tron as a party or appointed arbitrator in this case. Now, unrelated to this case and unrelated to these parties, arbitrator Tron is an advisor to a third-party funder named Danang. I presume does everybody know what a third-party funder is? Or maybe I should explain this. Does everybody know? Okay, so a third-party funders, of course, are people, there are many different types of funders, but they are parties that fund one side, and their role is just to fund and drive profit, sometimes not for profit, out of the result of the decision. There are also, of course, third-party funding is not so popular in Vietnam. And actually, third-party funding is not so popular in many civil law countries, but is very popular in common law countries. In international arbitration, you should be aware of what they are because they're very active. So, like I said, the third-party funder, usually for profit, usually will be funding a claimant. And oftentimes, not always, oftentimes it's a claimant that doesn't have enough money, but has a really good claim. So they want to bring the claim, but they don't have the money to bring the claim. So this is just a typical scenario, but not the, so the funder will fund the claimant. And if that claimant wins, then the funder will get a chunk of the money that's won. So they're doing it for, but that's the typical scenario, but there are other scenarios. But that's your typical for-profit funder. So in this case, Tron is acting as an advisor for a third-party funder. Because when third-party funders are funding, they have to decide which case to fund. And it's important that they fund, of course, a case they think they're going to win, and the case they think they're going to get a good win. So they need advice from experts. So in this case, Tron is advising a third-party funder, Danang, and the third-party funder, Danang, it's usually a company, and sometimes these companies are very, very big, has funded a party unrelated to Venus or Mars, another party, in their litigation or arbitration, where the same law firm, Hanoi, is being used. So this is also considered a potential double-heading situation. So the idea is that since Tron is advising Danang as to which companies or which parties to fund and which law firms to use, sometimes that's connected, sometimes it's not. But the perception is it could be connected. And Danang has chosen to bring a case in another case, another party, but they chose to use Hanoi law firm. Then Hanoi law firm is grateful for this appointment. And they've been retained to a case. So Hanoi law firm, coincidentally, or because they feel grateful or indebted or whatever to Arbitrator Tron. They appoint him Arbitrator Tron in the case Venus is Mars. So this is a potential double-heading conflict is the issue. I think third-party funding was a bit too difficult, but I'll try to explain it again if people really want to know. But again, so just think of a party, a claimant, and of course there are many, many claimants that have a good claim. Let's say they believe the respondent has violated a contract, and the claimant should, if they sued, they could win $10 million. But the legal fees to bring that claim cost a lot of money. Let's say $500,000. But the claimant doesn't have the money. So they could win $10 million if they brought the claim, but they don't have the $500,000 fee, legal money to pay the lawyers. So a lot of claimants and parties will just give up. So what the funders will argue is to provide what they call access to justice. So we'll fund the $500,000, the legal fees, and help you bring the claim. And of course, if they win, they're going to get $10 million. And the funder gets a chunk of the $10 million, let's say $3 million. And the rest goes to the claimant. So everybody wins. The claimant at least gets some money, not all 10 million, but they do get some money out of this. And they do get some justice out of this. This is the scenario. But like I said, there are many different permutations, but this is your typical third-party funding situation. And like I said, it's not as common in civil law seated cases, but it's quite common in common law seated cases and in international arbitration, particularly if it's a big case. All right, I shouldn't spend too much time on third-party funding, but it's just an interesting issue. Okay, let's move on to investment arbitration. And this is where there's a very, very hot debate. And you have some very serious kind of policy discussion going on right now. And a similar debate also exists in sports arbitration. And just for anyone that's interested in sports arbitration, they basically prohibited double-heading. So in sports arbitration, if you're an arbitrator listed on the CAS, that's one of the leading sports arbitration institutions, you cannot act as counsel. They just prohibited it. Investment arbitration, they're deciding upon this. Okay, so investment arbitration is, of course, an investor bringing a case against a country, right, against a sovereign state. So here again, we have Arbitrator Tron has been appointed in Venus versus state of Mars. And in this case, Arbitrator Tron is also acting as counsel, as a lawyer, in another investment arbitration case, Saturn versus Pluto Republic. Different investor, different claimant, different respondent. Now, in the first case of this Mars is relying upon Saturn versus Pluto, the award from Saturn versus Pluto, because there's an arbitral award there. However, Counsel Tron is trying to set aside that same award. Okay? So one party is trying to rely on that award, but one of the lawyers, one of the arbitrators, in a different case, in that different case, is trying to set it aside. Okay? So as a counsel, he's trying to set it aside when he's wearing his counsel hat. But when he's an arbitrator, or she is an arbitrator, have to decide how much weight to put on this award. Okay? So the double hatting issue is much more prominent in investment, and particularly sports arbitration, because of this reliance on prior jurisprudence, which is widely done in investment arbitration and sports arbitration, but not really done in commercial arbitration. So this is probably the biggest difference. Okay, so some would view this as an issue conflict because of double hatting, and this creates issues in many people's minds. Similar thing. Arbitrator Tron, remember, it's basically the same scenario, is an arbitrator in the first case and has to decide on a particular legal standard. In investment arbitration, one of the most hotly argued issues is the fair and equitable treatment standard. We call it the FET standard. Now, as an arbitrator, arbitrator Tron has to decide, but in the second case, as we saw before, arbitrator Tron is arguing FET should be interpreted this way. So again, when arbitrator Tron is putting their counsel hat on, they're going to argue it one way, but can they take their hat off, put on their arbitrator hat, and be open-minded and neutral again? Can arbitrator Tron switch his hats off back and forth like that? That's the question. It's much more prominent issue, therefore, in investment arbitration. Okay, now I'll try to work through some what some might call pros or cons or heads and tails. Okay, now the heads, some would think some positive aspects that should be highlighted and not faulted of double hatting. So if you have someone like Ms. Dao or Dr. Le, who's very capable and is hardworking, diligent, independent, and has integrity, and really knows, has a lot of experience in international arbitration, then there's nothing wrong, or it's not an issue if a person one day wears counsel hat, next day wears arbitrator hat. They're able to do this, no problem. Because if you think about it, lawyers have to argue for their client. And even if they're not an arbitrator, one day they might argue one thing for one client in court, and the next day they might argue something else, totally opposite, for another client in a different case. That's nothing, you don't think anything's unusual about that. But it's this question is when they become an arbitrator, this triggers the issues. So in terms of quality, because a lot of these people have lots of expertise, it's not a problem, some would suggest. Also, if that's what the parties want, and remember, arbitration is a party autonomy, as long as the parties don't challenge, and that's what a particular party wants, they want a particular arbitrator, or they want a particular chair, And of course, if they consent and it's not a problem, then it's probably not as big an issue. And a part of respecting party autonomy, then double hatting is not as big as an issue. One of the biggest reasons some say there's we should not try to restrict or narrow down or regulate double hatting is the diversity issue. Now, what happens is for the double hatting issue, a lot of this occurs because counsel are appointed as arbitrators, particularly in investment arbitration, in particular sports. But a lot of times when the counsel is appointed as an arbitrator in the arbitration world, they're often appointed as the party appointed arbitrator. Not always, but often. And generally, there tends to be, particularly for bigger and larger cases, the chair is someone who's kind of no longer does counsel work and just acts full-time as an arbitrator, and they don't have this conflict or double hatting issue. Now, there's criticism that arbitration is a closed field and you have to be part of like a mafia, and unless you're part of the mafia, you can't be an arbitrator and all this stuff. So, and that's a legitimate concern. Only very few people seem to get appointed a lot, frequently. So you need to diversify that pool, and this will help add legitimacy to international arbitration. So for that to occur, you need counsel, particularly junior counsel, to be appointed as wing arbitrators, particularly. And this includes not only, when we're talking about diversity, it's all kinds of diversity, not only age, could be ethnicity, could be gender, all kinds of diversity. Because if you don't do that, and if you don't allow counsel to participate, it's just going to be the same pool. Its pool's not going to grow. So this is one of the strongest arguments that we should be very careful if in trying to regulate some way or in a very tight way, double hatting. Now, the tails, kind of the concerns that exist are various. And of course, as we've already raised some things, this issue of perception. Is that person going to be able to switch around like this? Can they really be that neutral and objective in their mind? No matter how hard they try, and maybe they're really honest and they try to do, they really want to, but subconsciously, even they're going to be influenced, is one concern. And it just doesn't look good. How can this person one day be arguing this and the next day be arguing that? Something doesn't seem right to this system. It undermines the legitimacy of the system. This is another concern. And when an arbitrator is getting appointed, and of course, when they're, sometimes you might be concerned that the person, if they're a lawyer, can't make full disclosure about all the parties that they're representing in case, because there might be some cases for whatever reason that they can't disclose. Then do they kind of, do they get permission? Are they getting permission? Are they trying to meet their duty? Can they meet their duty of confidentiality while meeting their duty of disclosure? There's going to be conflict even for the arbitrator. So there are some arbitrators who, if any issue, they'll just immediately resign. There are some that do that as well. Now, in investment arbitration, the debate is what to do. And some would suggest regulation is necessary and should be done. And this is a very hot topic right now in the investment world. Some are proposing prohibition, like sports arbitration. So if you're going to be involved, if you want to be an arbitrator in investment arbitration, you should not do counsel work. Don't act as a lawyer. Just be an arbitrator. That's what some suggest. Or some suggest kind of a disclosure model. Okay. And the three scenarios, these are the three options that are being debated right now. And UNCITRAL, you're all aware of the model law, right? And the UNCITRAL work of the UNCITRAL in terms of the model law and arbitration rules. UNCITRAL and ICSID, this is the current third version that came out, I think, last fall of the draft code of conduct for what they call adjudicators or arbitrators and others. And these are the three options that I just said. One is full prohibition. One is kind of a modified prohibition, narrower scope of prohibition with disclosure. And one is just no prohibition, just full disclosure. And then you see what happens. So generally people think that we're going closer to the modified prohibition. And the modified prohibition at this stage is what we have right here. So for those categories that are listed there, you could not serve as an arbitrator. So if you're counsel and you're dealing in a case where the same measure exists, same government measure. So let's say Republic of Mars has a permit, licensing permit. That same measure is being debated in another case where they're potentially going to be an arbitrator. That case, they would not be allowed. Second case would be same legal issue. As I mentioned, for instance, like fair and equitable treatment, expropriation. Of course, it depends on how broad or narrow you're going to define that issue. Third one would be same parties. So usually, of course, it could be either same claimant or investor, or it could be the same state who's the respondent. And the fourth potential category is the same treaty. So Vietnam and US bilateral investment treaty. I'm not sure if there is one, but maybe there is. Now, you just not be permitted unless the parties consent. If the parties consent, then that's fine. Otherwise, will not be allowed. This is the second option that's currently being considered, and some suggest has the greatest potential. Of course, then the issue is which issues would not be permitted. Okay, the last thing I touch upon is arbitrators as mediators. And of course, arbitrator one on the same case, of course, this is particularly, and this is of course the ARB-MED, ARB or MED-ARB situation. Same case, they're arbitrator, take off their hat. Same case, they're a mediator. Now, this is not so common in many jurisdictions, but it is common in other jurisdictions. And of course, I'm told it's very common in Vietnam. So, of course, if the parties agree, then it's not much of an issue. But again, this is another form of double hatting, and similar issues can arise. Okay, I hope that provides a general overview for you, and I hope I've been able to explain the third-party funding issue so you have a better sense of it. But look forward. We already got a lot of comments. Unfortunately, I haven't been able to read all of them. But let's hear from Dr. Le and Ms. Dao. And while we're hearing from them, I'll also try to look at some of the questions and work through those as well. Okay, Dr. Le.
Thank you very much, Professor Kim. It was my pleasure to learn from your presentation, and I'm sure other audience also learn a lot from your presentation. And that is true that double heading is dealing with a case when one person is an arbitrator, and at a different time he is a lawyer, maybe for the same client, maybe for a different client, but with the same colleagues of lawyers that once appointed him as an arbitrator. It could be the same, maybe that his colleague in the same firm act as an arbitrator for a case where one of the party in which he is that was his client. So the situation could be broad. It doesn't have to be narrow in one or two situations. And I think I agree with you that the example could be many, and therefore it could avoid what we look at. We should look at the substance rather than the way or the form that how a double heading should be formed. My experience when I was appointed as an arbitrator in, let's say in Singapore, they don't use, let's say an IBA guidelines of conflict of interest. They just give us a general guidelines. You have to disclose if there is a conflict of interest with the following person. And the list of person is very extensive, is including lawyers in one of the parties, from the claimant and respondent, not just the firm, but Mr. X, Y, Z, and so on and so on. Are you their friends? In what circumstances they are your friends? And also the name of the parties and the subcontractor of those parties and the subsidiary of those parties. And I have to disclose all. And I have to disclose that I know Mr. X, Y, and Z. I know Mr. X, who is the counsel of the respondent. I know Mr. Y, who is the counsel of the claimant. I know both of them. I have acting for a client whose adverse party was one of the party of this case. So I have to list out all of those, and then the chair or vice chair of the VIAC arbitration, they will make decision whether I could be appointed as an arbitrator or not, and her decision is final. So sometimes he just say that she decided I should not be the arbitrator, and that's all. I have no appeal, and there's no reason why and why it's not. Now, when we look at Vietnam law, it's a little bit different. If I can share the screen, and is about the case of in which there could be the just one moment. Yes, so that is, yeah. So it's when it's on the screen, you see that there is a change, the trial of arbitration. In Article 42.c, that has to say that there is a clear ground to conclude the arbitrator is neither impartial or objective. To prove a clear ground is very difficult. Like to prove a fraud is almost impossible. What is the standard under the UNCITRAL modern law? The UNCITRAL modern law, they say that an arbitrator, he might be they may be challenged if there is a justifiable doubt. So it doesn't have to be a clear ground. It could be a justifiable doubt. And that is the system, the difference between the system, and that is how they preserve the impartiality and unbiased of the system. Of course, as a human nature, people are biased in general. I mean, you must have a view about the war of Ukraine. You cannot say I need to support Russia or Ukraine. You do have a view. You do have a view about how what happened when the investor is prejudiced upon by the state. Some may say that the state interest has to be protected. Some may say that the private property has to be protected. They have their view on that. And that is the reason why we see that lawyers, they may post a lot of views on the internet, on the Facebook, but you never see arbitrator post their views on the Facebook or internet. Or you rarely see them even write articles on the published, on the journal, scientific journal. Their name is very famous in the community of arbitrators, but you don't see them published because they suspect that their view can be considered as biased because they already wrote some articles about those. Now, if you look at the statistic, Professor Kim rightly posed about arbitration, investment state arbitration, and it's very interesting to see that. Let me show the statistics. So on the screen here, you see that let's say some person very famous like Professor Kaufman-Kohler, she sat on 27 cases. Professor Bridgestone, she sat on 37 cases, and they are in the closed community. That is from the statistics of publicly for those who make a research on exit cases. Why they can pull out that name? Because exit cases are public, so they can run the public search during so many years, and they come into those. Professor Jan van den Berg is set on 19 cases, and Professor Yves Fortier is set on 23 cases, and on the same standard. Let's say Professor Jan van den Berg, she sat with Stern. He also sat with Stern. He sat with Emmanuel Gaillard. At the same time, Emmanuel Gaillard is very famous partner of Sherman and Sterling. We know that. We all know that. And Professor van den Berg is a professional arbitrator, but Professor Gaillard is the lawyer and arbitrator at the same time. Professor Stern is a professor of the university, but at the same time, she is also an professional arbitrators. And then you see the same name, Professor Brouwer, Mr. Brouwer, and then Professor Gaillard sit with Professor Hanotio, or Professor Kaufman-Kohler sit with Professor Gaillard, or Professor Jan van den Berg. So what would those statistics shows? There's an inner circle or a small community of arbitrators. They appoint each other. Is that the situation the same in SIAC or VIAC or ICC? Because this is confidential, we don't know. But I think in the Secretariat, if they make a statistics like this, something similar would point out. So I think that situation is real. It's not something that somebody imagined. When we look at the statistics, the article, the so-called, and where I download it from, I don't know. You see that article on the screen now, or just the Excel? You see the article, Profiting from Injustice, or you haven't seen that? Otherwise, I show it again. So what does that mean? What is the finding here? The finding here, the key finding here is that the number of investment arbitrators case has been surged in the last 2 decades. And legal arbitration cost has been increased. So I remember when we were appointed as VIAC panel in 2007, the arbitration fee is very small. And we all work for, not for money. We work for hobby, for the sake of justice. But that's in VIAC. But in, let's say, SIAC on ICC, the arbitration fee is substantial. And when something is becomes substantial, it does impact something. We cannot say that doesn't matter what the money is big or small, it doesn't impact at all. So, and then key finding number 3, international investment is dominated by a small and Northern Hemisphere-based community. 3 top law firms, Freshfields, White & Case, and King & Spalding, claim to have involved 130 investment treaty cases. Just 15 arbitrators, nearly all of Europe, US, Canada, have decided 50% of all known investment treaty disputes. So we in the panel, we have hundreds of arbitrators, but only just 15 arbitrators decide 55% of all known investment treaty cases. And that's in small group of lawyers, referred by some, mafia, sit on the same arbitrator manner, act as the both arbitrator, counsel, even call on each other as witness in arbitration cases. This has led to growing concern, including within the broader legal community over the conflict of interest. And arbitrators tend to defend private interests right above public interest, revealing inherent pro-corporate bias. And then I don't know whether this article, I don't agree with that conclusion, but at least the fact that they shows on the Excel files did tell something. So what should we do about it? One of the solution, as Professor Kim suggests, that maybe we should have lawyers do lawyers' work, arbitrators do arbitrators' work, and we have professional arbitrators vis-a-vis and professional lawyers. But the people who counter that proposal say that, well, the arbitrators who is also the lawyers, they have 2 sources of income, one being lawyers and one being arbitrators. And therefore, they wouldn't mind if they lose. I mean, they will not be appointed as an arbitrator in a case, and because they have another source of income because they are a lawyer. For the professional arbitrator, for example, well, if they are consistently appointed by, let's say, one of the leading law firms, then next time, if that and whatever he was appointed by that particular law firm, the client presented by that law firm almost always win. Then in the next case, if that particular law firm appointed him, would he mind of the justice and make a ruling that the lawyers represented that the client that has been represented by that lawyer lose? And winning or losing is not a problem for him, and it doesn't impact his future appointment at all. I'm not talking about he did something like under Article 68 of the law on arbitration, like receive money. I can assure you, no arbitrator receive money like this, because their arbitration fee is good enough. But the appointment of arbitrator generate the source of income. So that is the situation whereby the arbitration center, they have to make decision whether they should go for a broad definition like SIAC, or they should go for a narrow scope of checkbox like the IBA rules of conflict of interest. and that I would like to invite your comment on that, Professor Kim, and also Ms. Linh, as well as the participants. Thank you very much.
Very much, Mr. Liu. Maybe we should hear from Ms. Dao first, and then maybe I'll try to deal with both of your questions and comments after that. Ms. Dao?
Yes, thank you very much, Professor Kim, in particular, for your very insightful presentation, and also very useful and informative comments from Dr. Linh. And I guess in order to add more color to the discussion today on the topic of double hatting, I'd like to provide some more information of the issue from the perspective of VIAC as an arbitration institution administering a lot of arbitration cases in practice. And for that purpose, let me please bear with me one moment while I share my slides. Yes, so I would not, in order to save time, I would not repeat what Professor Kim has provided for interpretation or definition of double hatting, as well as the advantages and disadvantages that has been presented in his presentation. What I would like to focus on is what VIAC has observed during its practice in reality. So I agree that the common circumstances that usually appear in Vietnam and also in general, and also at VIAC's practice in particular, falls under two circumstances, including an arbitrator who also acts or have acted as either mediator or counsel or expert in the same or related matters, or arbitrator who also acts as counsel or lawyer in different matters for the same or different parties. These are the common circumstances that have been seen in reality with both pros and cons. For these circumstances, the double hatting issues mostly concerns the circumstances of arbitrator and lawyer dual roles, which is due to the particular characteristics that Vietnam legal market in general and arbitration market in particular are rather small. In fact, more than 30% of VIAC's listed arbitrators are also practicing as a lawyer at law firms of different scales, either domestic or international one. Whereas we rarely have cases where arbitrators also act as experts, and in those few cases where arbitrators also act as experts, VIAC has not encountered any challenges as to these particular circumstances. The reason may be because their practices, both as arbitrator and expert, are quite separate and do not any kind of or any source of conflict of interest. Whereas for the case of an arbitrator who also act as mediator, I have not seen any cases as such, because this is expressly prohibited by the law on commercial arbitration, as well as VIAC's rules of arbitration. And out of all the advantages and disadvantages that has been presented by Professor Kim, what we've experienced the most relating to are the advantages and disadvantages relating to challenges to arbitrator. That is one part of the coin, one side of the coin. And also on the other hand, we are able to take advantage of the arbitrator's diverse background and expertise. And the most firm example of this is that the majority of arbitral tribunals constituted under VIAC's rules normally comprise of at least one arbitrator who used to act or is currently act as a lawyer at a law firm at the time of appointment. So with these issues of double hatting coming across, how do we as an arbitration institution administering the whole proceedings tackle the issue? Now we deal with this issue of double hatting by regulations, firstly, and secondly, education and training. And thirdly, the system where we handle challenges to arbitrator. Turning to the first tools, which is regulations, we have the law and the rules. For obviously in Vietnam, the law that mostly used mostly governs the proceedings is the law on commercial arbitration of 2010, in which we have Article 42, which provides that the arbitrator has to decline to act in an arbitration, or the parties also have the right to challenge an arbitrator if the arbitrator was a mediator or representative or lawyer of any parties prior to the dispute being brought to arbitration, unless we have written consent by both parties. Similar provision can also be found in Article 16 of VIAC Rules of Arbitration 2017. And also similar obligations is imposed on all the arbitrators participating in VIAC administered arbitrations in the Code of Ethics that is applicable to all arbitrators at VIAC. So the Code of Ethics is also part of our internal regulations in order to regulate the issues of double hatting and in general, and arbitrators' duty to remain impartial and independent in particular. Apart from that, a strong tool that VIAC has been using in order to control the process is the arbitrator statement. So some of you might be familiar with this arbitrator statement if you have had a chance to participate in one of VIAC's administered arbitration. So the arbitrator statement lists out the circumstances where arbitrator shall decline to act in a particular case, or shall accept to act, but with appropriate disclosures of fact or circumstances related to their independence and impartiality. The VIAC's arbitrator statement actually resembles the very famous IBA guidelines on conflict of interest, but with a little modifications in order to adapt in the Vietnam arbitration market. The second method that we use in order to monitor the process is through education and training. So we at VIAC we provide education and training for two kinds of participants in arbitration proceedings, including arbitrators and also users. So for arbitrators, we have regular internal trainings to both newly admitted and also existing arbitrators in order to provide insight into the issues of double hatting, their ongoing obligations to remain impartial and independent, and also guidelines on how to conduct conflict check and make appropriate disclosure. Now for users, including lawyers, in-house counsels, and also other kinds of party representatives, we organize a lot of workshops and seminars and also professional training in order to provide insights into the issue of double hatting. Also guidelines on how to use their rights to challenges in an but of course in a very appropriate manner, which reveals the improper acts in the arbitral proceedings, but at the same time does not tactically hamper the integrity of the proceedings. Now, for users, we recently launched the Vietnam Institute for International Arbitration Research and Training, of which one of the focus is on the arbitration training, which provides professional training on arbitration, which aims at providing insights into arbitration proceeding, including topics, specialized topic like this one, double hatting and arbitrators' duties. We also manage the arbitral proceedings in relation to the topic of double hatting through our system where we handle challenges to arbitrator. So we have designed our procedure very carefully in order to ensure that all the challenges to arbitrator are duly considered, which leads to the final decision on either replacement of an arbitrator or non-replacement of an arbitrator. An arbitrator can only be replaced in circumstances where issues relating to double hatting, for example, are so serious that could hamper the proceedings. On the other hand, an arbitrator cannot be replaced in circumstances where challenges are found to be frivolous and only considered as an attempt to delay the proceedings. All of these tools that I've now mentioned previously in my presentation is in order to protect the integrity of the arbitral proceedings at VIAC, and also at the same time reserves the advantages of one of the advantages of double hatting, that is to reserve the diversity and expertise of arbitrator acting in an arbitration. So I believe those are all the information that I have at hand to share about the practice of VIAC from VIAC's perspective as an administering arbitration institution. Thank you.
Okay, thank you very much, Ms. Dao. I'm going to first, I think I should try to address many of the questions. We're grateful for the questions that have come up in the chat, and the questions I can't unfortunately address all of them, but I'll just try to address some of them. And then I'll try to address some of the issues, interesting issues that Dr. Le and Ms. Dao have raised. There was one very good question. Of course, I note that in Vietnam, I guess there's a saying that a jack of all trades is a master of none. We have a very similar saying in Korea as well. I think it's a Nun Kun says, an arbitrator who acts proactively as a lawyer, who's sitting in a big case as an arbitrator with a big corporation. And the question is, can they act neutrally because they might feel pressure if they decide against the big corporation? And of course, in the real life, while that arbitrator is an arbitrator, they also are a lawyer. And if they rule against the big corporation, they're worried that they might lose potential business or a potential client. So isn't this going to hurt the arbitrator's independence or impartiality? I think this is a legitimate question, but if you think about it, that's every case. I don't think it matters whether it's a big corporation or not. The role of an arbitrator, of course, is to be neutral. But I think the key thing is the arbitrator needs to maintain their reputation, and that's the most important thing you have as an arbitrator. If that person, and everybody will, the world is a small world. If that arbitrator is biased and it shows in their decision-making and in the award, trust me, everybody will know very quickly. Even the company that benefited would know that as well. That's not a reputation you want to have. And if you have that reputation, your life as an arbitrator will be very, very short. So if you want to impress the big corporation, you should be very, very rigorous and even more neutral. To impress the big corporation, well, that person is really hardworking, knows their stuff, and is really neutral. And they didn't vote for us, but they heard everything we had to say, and we're persuaded by what they say, right? And if you're able to do that, then you're going to build a reputation as an arbitrator. What I think as an arbitrator, the highest bar to show that you've really succeeded as an arbitrator is if you've ruled against a party and the party next time around appoints you, right? That shows they really impressed by who you are, even though they lost. And the top arbitrators, that's how they maintain their reputation. And that's what I think you need to strive for. Second situation, of course, and there's a lot of general concern about double heading. People are worried about this perception that how can one person do this at the same time? I guess, like I said earlier, if you're someone that's very able, like Dr. Le, one day you're going to be, and that's the role of an advocate. You have to argue for your client. So for one client, maybe you have to argue it this way in this case. But for another client, you have to argue maybe the same point in an opposite way. That's what an advocate does. And that's what lawyers are trained to do. And if you're trained to do this very well, some would suggest you should be able to do the same thing as an arbitrator as well. You have an open mind, and each case is independent, and you'll have fresh eyes, and you can do that. Some might suggest, no, if you've worked so hard for a particular issue, and particularly the older you get, your mind gets very rigid, and you just think like that, and you can't open up your eyes. And that could be a concern. That could be a concern. But for the good counsel, I don't think it's that big a problem, but that's not everybody. Another person, Din Long, is asking that a person has worked in arbitration cases as a lawyer assistant, and their senior has acted as an arbitrator, and does the acting as an arbitrator help being a lawyer? I think that's true. Most people say once you've sat as an arbitrator, it totally changes your view, and you learn so much as to how arbitrators think. And of course, at the end of the day, if you're a lawyer, you need to persuade the arbitrator. And if you've never acted as one, and if you've acted as one, it's much easier to think like one. So you probably become a better advocate. Okay, we can talk a lot about investment arbitration. This is a field that I'm very closely involved with. And I'll just bring you some statistics, some current statistics. And this is the current statistics from ICSID from 66 to last year. And as you see, yes, 66% of the cases, 66% of the arbitrators appointed in ICSID cases are from Western Europe and North America. This is true. But 34% are now not from those places. And trust me, 10 years ago, it was much higher, okay? So the number of arbitrators from these regions has risen dramatically in the past 10, 20 years. And it's increasing dramatically as we speak. So if you look here, at the bottom, you see the times when ICSID makes an appointment and when the parties make an appointment. Now, arbitration is about party autonomy. So the parties tend to prefer, and this is both the investor and the state, they tend to agree on people from North America and Western Europe. But when given the choice, ICSID tends to appoint more diverse people that are not from Western Europe and North America. So ICSID is very conscious of this, and they are really working hard to diversify the pool. And it's increasingly diversified because it was not 34% even 10 years ago, or even 5 years ago, okay? So the pool is diversifying. So to give you a better flavor, these are the statistics for those. I just tried to pick up the major one. From Singapore, already 36 cases, Korea, already 17 cases. 5 years ago, basically, it was almost zero for Korea. And of course, China, Bangladesh, Malaysia. Unfortunately, I couldn't find anyone from Vietnam, but trust me, there will be someone very soon. So the numbers from Asian arbitrators is increasing dramatically. And they're working very hard to change this issue. And it's important. Of course, arbitrators should not all be from Western Europe and North America, but that's the case also for commercial arbitration as well. And I can talk a lot about this, but I won't spend. Now, in terms of what Dr. Le showed you of those top 15 arbitrators in investment arbitration, you could probably say the same thing for commercial arbitration as well. There are some top arbitrators, they are repeatedly appointed by everybody. And there's a reason for that. It's because most of them have built up a really, really good reputation of being really, really fair, thorough, independent, and high integrity. Okay. And that's why they get repeatedly appointed. And that's why both parties agreed to appoint them. From the flip side, you can criticize them for being repeatedly appointed. But if both parties agree, that shows that both parties really think that person is really competent. Otherwise, they wouldn't get appointed, right? And those parties, those persons, not all of them, but most of those persons, those 15 people that are people that were agreed by both sides. Or, of course, one particular side really likes that person. Okay, so there are some arbitrators that are highly favored by investors, and there are some arbitrators that are highly favored by states, and there are some arbitrators that are highly favored by both. So if that's the case, it's actually, you can think of, some would suggest it's a very robust system. And it's not because they're necessarily appointing, even though they might want to recommend each other, if the parties don't agree, usually they cannot be appointed. Okay. So yes, it's an inner circle. Yes, there are various in an error pool, but some of these people have really, really worked hard to build their reputation. And if they are biased and there's something wrong, trust me, they're not going to get reappointed, and they'll quickly lose their reputation, and they won't be among that 15. And hopefully, of course, one of you in the near future will be part of that 15. We need more able Asian arbitrators, trust me. Now, third-party funding, again, I can talk about this a lot, but just to give you one thing, like I said, I only showed you one typical example of third-party funding, but there are also third-party funders that fund governments as well, not for profit, because they just think it's the right thing to do. So you can't, it's very difficult to categorize third-party funding, but it's reality. And again, like I said, there are some very, very meritorious parties who really have a strong claim, particularly in commercial arbitration, where they, and I'm sure there are many, many Vietnamese companies like this, they really were wronged by another party, and they have a very strong claim, but they don't have the money. They can't pay the lawyer's fees. Then in many cases, they'll just feel so bad. We have a strong claim. We just don't have the lawyer money. Then in that type of case, the funders suggest they can help and provide access. Now, there are other situations where but that's one scenario where one might think a funder could help a party that needs the help. Okay, I think we're probably, I don't know. Let's see what else.
Professor.
Sure.
Before you moving on with the next question, I'd like to take it back a little bit to the very first question, where the audience asked about the situation where an arbitrator also is appointed, but he is also acting at the same time as a lawyer and afraid of getting out his ruling against a big corporation. So in general, I absolutely agree with all that you've given to as an answer to the question. I just want to add a little bit more on the perspective of an arbitration institution administering arbitration cases. So in similar cases, we usually guide our arbitrators in similar cases that if from the beginning of the appointment, when he receives the appointment, he needs to examine whether he can be and can remain impartial and independent from the beginning and throughout the arbitral proceedings. If he has just even a little concern, himself has a concern about his ability to be and to remain impartial and independent, then he's already biased. And in that case, of course, he should decline at the beginning of the process, decline to act as an arbitrator in that case. Because if he is impartial enough, independent enough, he would not be afraid of getting out his ruling against that big corporation, no matter big the corporation is. And in that case, I believe it is about his ability to separate the role, his role, while wearing the hat of an arbitrator, and on the other hand, wearing the hat of a lawyer or counsel.
I couldn't agree more. Only thing I would add, of course, it could be her role as well. So if the person harbors any doubt before or during, they shouldn't accept the case. And of course, yeah, that's just the end of the story. Yes, they shouldn't accept, and if during the case this comes up, they should resign. Yeah,
exactly.
Yeah, I couldn't agree more. Yeah. Dr. Liu, I think you want to add something, but you're on mute.
Okay, thank you. Professor Kim and Ms. Linh, I also agree. I think the most important thing is that you agree or disagree, you have to disclose. Of course, at the time you don't know, you don't disclose, but at the time that it appears to you that there is a situation of conflict of interest, maybe you assume that the people must know because of the circumstance of the case, the lawyers are the same. Two lawyers are the same and they are in a different case, but they must know each other, or the parties, they must communicate each other because their interests are so close that they should have known. To play safe, you have to disclose. I mean, the sooner the better. And I think before the case has gone into the substance, if the two arbitrators were informed that the third arbitrators could be objectable, and one of the party object, I think I saw that the arbitrators are quite hesitant to replace the third arbitrator because there is no facts, or there is no legal basis under the current law, because the current law requires to have a clear ground, which is there is no clear ground. There's just some suspect. There's just some doubt. Even using the UCITRA rule named the justifiable doubt. But I think the best approach at that early stage is to replace him. Even at the later stage is to replace him. It costs some money, yes. It's pity, yes, but it's safe. At least it's safe for the party who appointed him, because later on their award, if they win, would not be a challenge upon. And it should be, I mean, people should treat the replacement of or resignation of arbitrator is a normal situation. It's nothing bad with that arbitrators. It's better to stay away and keep independent rather than make a decision and make people doubt. So I saw and I did have a discussion and they say that statistically the chance of winning challenges is very little. The chance of winning challenges and arbitration is very little. Is that good or bad? I don't think it's good. I mean, people should be more open to challenge arbitrators if they have a justifiable doubt. And is that a tactic of delay of justice, of injustice? We should not assume that whoever challenges arbitrators, they just want to delay the justice. Maybe because the stake is too high. They cannot live with doubt. There must be no doubt. And as you said, you have a small circle of arbitrator. Why don't broaden it? Why don't you broaden it? So, I mean, if you don't do that, where is the chance for young arbitrators? Where is the chance for the new generation of arbitrators? Of course, there is a trend to appoint people at the same rate. Professor Kim, you said that the wing arbitrators should be young arbitrators and the chair should be more senior. But the problem is that at least in our culture, Asian, the junior listen to the senior. They pay a lot of respect to the senior, and they are not at the same, so to say, rank to oppose the opinion of the senior, and that might be a problem as well. So at least for us as Asian, we should oppose that kind of culture. We should treat, which is the law. I mean, all arbitrators equal, young or senior or old. They should be treated equally. As long as they are right, they should be given merit. So I quite agree with Ms. Linh approach is training, education, and rigorous challenges. And there should be no hard feeling of being voted out or being replaced. It should be normal. And there's no sanction about that. Nobody assumed that you have a bad intention by accepting arbitration. Maybe you forgot. Maybe you think that people should know, but in fact they don't know. Whatever. But for the sake of clarity, you just replace people. That's it. I mean, does it delay the situation? Delay the process? Depending on the nature of the case. The fact that the case costs $100 million doesn't mean that this case is complicated. Sometimes it's just a collection of debt. But the fact of the case is $1 million doesn't mean that it's not complicated. Maybe if that's a big commercial dispute, construction dispute related to delay and impact and so on, it's very complicated. So in that case, we should be mindful about the nature of the case, whether the replacement would delay the process or does not delay the process substantially, and make decision accordingly. And I think it should be fine for the arbitrator who will be replaced or would be replaced. Thank you.
Thank you, Dr. Loeb. I agree as well. Education and training, of course, is critical and very important. I agree, of course, that parties should feel free to challenge when they have doubt, justifiable doubt of arbitrators' independence or impartiality. They should not be hesitant to do so. Of course, some parties feel intimidated by doing that, particularly because they feel if they lose the challenge, then they're going to look bad, particularly in front of the tribunal. So of course, but you know, that's if it's a fair challenge, they should be brought. And the arbitrator should face the consequences. And many arbitrators, if a challenge is brought, they just resign. They don't even fight it. They don't want to deal with the issue. If there's any doubt and someone challenges, they just resign. Now there is a problem with that, of course, and of course some parties and lawyers abuse the system, and they challenge too much, and for issues that are not serious issues. And this is kind of a guerrilla tactic to delay the system. And that's also a problem as well. And some would suggest in that situation, then an arbitrator should not resign, because this is a party that's trying to take advantage of the system. So challenges is a complicated issue. For the wing arbitrator and the chair, I'm not advocating that the wings should be juniors. I'm just saying statistically, that's often the case. And statistically, the wing arbitrators tend to be a lot of times people that are currently counsel as well. And yes, sometimes no, you're going to appoint very senior lawyers who are counsel still as wing arbitrators too. But at the end of the day, even my view is, even in Asian culture, yes, there is going to be some deference to someone senior, but I think it's, at the end of the day, it's who knows the case the best, who's worked hardest, and who knows the issues and the facts the best. Because no matter how senior you are, if you don't put in the work, then a junior person who knows the cases better is going to be able to make a much stronger argument one way or the other, and will be swayed by that. And that's the type of person I think you should strive to become once you become an arbitrator. And of course, you'll gain a lot of respect, particularly from the senior arbitrator. And of course, the senior, if you're able to do that, senior arbitrator will rely on you much more, and you'll become a much more effective arbitrator. I caught a question from Ms. Min Tan, who suggests I've been a lawyer for 4 years, and if double hatting is prevented, then I'm considering, I don't want to give up my career as a lawyer, which is stable income, and maybe I shouldn't wait to become an arbitrator. It's a valid question, but I think, of course, in terms of commercial arbitration, remember, investment arbitration is a very, very narrow field. So commercial arbitration, I don't think the narrow definition of double hatting will be prevented, because particularly if there are cases that are unrelated and the issues are unrelated, then there's no real conflict. Then I don't think it'll go far as being there being a prohibition. So I don't think you should be that worried about that. I think the bigger issue, and I kind of forgot to talk about this, is the time conflict. And I think this is actually a serious issue too, because as Min Tan, I'm sure you know, if you're counsel, you're very, very busy. And your clients ask you to do so many things, then do you have the time to serve as an arbitrator? And being an arbitrator takes a lot of time too. So just because you want to be an arbitrator, and I know a lot of young people are very eager to become arbitrators, but you actually have to be worried about when you actually get appointed. Because if you do get appointed and you're not ready, that's not good either. That's because it'll show, and like I said, it'll really hurt your reputation. Okay, I appointed that person. I gave them a shot, and they were just so unprepared. They didn't say anything. They didn't know anything about the case. Why did I? That's not the reputation you want. So you might be young and eager to be appointed as an arbitrator, but you got to be ready to do it. And it's a serious time commitment. And it should not be something, oh, I just want to brag that I was an arbitrator. That's not what you have to make serious. And as a lawyer, that's not easy to do. So you have to realize this is not something that's easily done, and you should be very dedicated and committed, because a lot of people will be looking at your work and how much you're doing. This includes the lawyers, the other arbitrators, the institution, and word of mouth is very powerful. It's a small circle. I sat with that person, and that person's like the hardest working arbitrator I've ever seen. I was really impressed by how well, or that person didn't do anything, didn't read anything, didn't respond. Then that's not the type of reputation you want. Okay. Let's see. Yeah. So let's see. What else do I have? Queen Mary services. Okay. So Tan Tao says that Queen Mary's survey mentions the word of mouth is how an arbitrator normally is recommended and appointed. It is interesting that in Vietnam, it is mainly the long CVs to be looked at in search of an arbitrator. I think that's true, but we have a chicken and the egg problem, and this is a constant problem. So if you're a party or a lawyer and you're looking for an arbitrator, then you want someone with experience. So if you want some experience, then you want someone who's done a lot of cases. And then so you look for the long CV. So that's why those people keep on getting appointed, and their CVs just keep getting longer and longer. And that's a problem, because there might be someone with a shorter CV who's just trying to break in, and they're just as good, and they'll maybe even work harder, but they don't get the chance. But so there's a catch-22 there. There's a problem there. But one thing I have to say is, and I kind of, I don't know, this is maybe because I'm getting older now, but you have to be patient. And just the way it is if you work hard enough over time and you build enough experience and build up your reputation, and over time, there's a certain point you'll hit, and then appointments will come. But you have to build up yourself to be ready at that point. because if you're not ready, there are some people that are very, very ready earlier in their career, but most people, it takes time to build up that reputation and that knowledge and experience. And once that comes, the appointments will come. That's my experience. Okay. What else? I'm trying to find some other questions. So, okay, so this is from Hung Tran. Hung Tran says that double hatting doesn't occur among legal practitioners since arbitrators come from various areas of expertise. Most arbitrators play multiple roles or even have to do so to keep themselves sharp at their industry knowledge, and therefore double hatting is inevitable. So the problem actually does not lie in synchronizing multiple hats themselves, but lies in the ways arbitrators use their sets of skills in arbitration, and importantly, the supervision from parties and the arbitration centers themselves. Okay, what I think the question is focusing on is in certain specific areas, specialized areas, like like construction or maritime disputes or intellectual property or investment or sports. In these type of specialized areas, definitely I think there's a higher likelihood of double hatting. And that's just the nature of the beast. Maritime arbitration, it's very, very, very common. And that raises issues, but I think it's even in the IBA guidelines, they have like a footnote that says in certain specialized areas, repeat appointments is very common, and it's to be expected. So I think for specialized areas, it's just something you have to expect more. And therefore, but like I said, in sports arbitration, they still prohibit it. They just put in a ban. And Min Tai says, I can see that double hatting is quite common. Is it a trend now and in the future? I think double hatting in commercial arbitration has been going on since probably the beginning of time, because lots of arbitrators, lots of the most able people in the legal profession are lawyers. Since they're very able, a lot of them sit as arbitrators. So I don't know if it's more of a trend now, but I think that's been a while. My plan is to take some skill courses at VIAC to become more knowledgeable about arbitration and start practicing as arbitrators in 5 years. The ugly truth is that judging on the current situation, arbitration in Vietnam cannot promise to secure a fair income for young arbitrators like me, and I still need to be a lawyer. How is the situation in Korea? Yes, I think that's probably true, particularly for domestic arbitration. In Korea, domestic arbitration, it's very different from international arbitration. So if you want to just be an arbitrator and only do domestic arbitration, there are not many people that just do that. But international arbitration is very different. So I would encourage you to try to explore international arbitration. And over time, of course, even domestic arbitration changes and the market will continue to change. But in Korea still, it's probably similar to Vietnam. Okay.
Professor, may
Yes,
I add
yes,
a little bit, since
sure.
this question concerns also about the courses that the audience actually want to start at or Vietnam Institute for arbitration research and training. I think the central issue of the question lies in the concern about the income of young arbitrator. But I think the problem is you should only be concerned about income of an arbitrator when you act as a full-time arbitrator and not as a young arbitrator. Because if you're a young arbitrator, this means that you just enter the market. Whereas if you're that young and you're just newbie to the industry, to the market, you cannot at the same time get as much appointments as you want. And in that way, you can never, and nobody can ever secure the income for you as a young arbitrator. Even in VIAC, over nearly 200 arbitrators in our list of arbitrators, only a few of them now or just recently become a full-time arbitrator after a very long time acting both as a lawyer and an arbitrator, or an arbitrator and another job in the industry that they're expert in. So for example, they're a lawyer and arbitrator at the same time, or they can be a construction expert and arbitrator specialized in construction industry at the same time. So that means only if time passed by and you've got enough experience and build up your reputation, as Professor Kim mentioned earlier, then over time you can come up with your own decision of becoming a full-time arbitrator. And at that point of time, you will never have to be worried about an income for a full-time arbitrator. And whereas for young arbitrator, our advice and also our purpose when organizing courses for specialized in arbitration is to provide a not only knowledge, but also a set of practical skills for persons who are interested in arbitration or wants to practice arbitration in the future, so that they are prepared to enter the industry, either as lawyers or counsels to the parties representative, or even at a higher rank, an arbitrator. So if you also attended the first webinar of this series, which discussed about the standard of arbitrator profession, you will remember that they discussed about the condition to become an arbitrator. And one of that is that you should have an expertise in a particular area, apart from your knowledge and skill in arbitration. You should have particular knowledge or even expertise in a particular area. For example, you're a legal expert. For example, you're an insurance expert, you have expertise in construction or maritime or sale of goods, for example. So in that case, you will use that particular expertise as well as knowledge and skills in arbitration in order to practice as an arbitrator. And in that case, it is totally possible when you already have a background knowledge of your own area, and then you come to attend our course in our specialized course in arbitration, get more knowledge and skill in arbitration. And in that case, you are prepared and ready to practice arbitration at the very first phase.
Okay, I can't agree more again with Ms. Dao. As a young arbitrator, these are challenges you have to face. And there are very few young arbitrators that solely rely upon being an arbitrator as their sole source of income. And of course, you shouldn't be sitting as an arbitrator for the income. That shouldn't be your primary motivation, because you're arbitrator, you're being like a judge, and your role, and you're being entrusted to act as this role. So income is important and it's an issue, but that shouldn't probably be your overriding motivation or your primary motivation. Okay, we have some other questions. Din Tian Huang suggests that you have a network of lawyers, and you'll frequently come across people with connections, and you have to disclose this, and disclosure will lead to challenges, and this will be time consuming, and the chain of consequences is irritating. In short, I am the view that the disadvantages of multiple roles or double heading outweighs the advantages. There's something to say about that. So yeah, if you're concerned about that, then you shouldn't be dual heading. There's it's not necessary. But again, as we tried to touch upon, we need new talent. You need new arbitrators. And the best way to become an experienced arbitrator is to sit as an arbitrator. And to sit as an arbitrator, usually you're going to do it part-time first, a lot of times while you have another job, whether it's as a lawyer or whatever. So first you start part-time, and then you do it more and more often. That's usually what people do. So yes, disclosures could attract challenges, but then you probably shouldn't take those cases to begin with. You should only take the cases where there's basically no likelihood that there would be a challenge, or unless it's an unwarranted challenge. We have another person, Tron Tom. I'm on my first arbitration case. I'm worried about the chance of annulment because we chose an arbitrator who we knew that he had as counsel dealt with similar cases so we can understand our position better. That's very common. But what if the opposite party challenges on the ground of double hatting? In your experience, how is their chance of success? How should I prepare for that? That's a very good question. This is, of course, comes up all the time. So you have, particularly as we talked about, in a specialized area, so you have a dispute in a particular industry. So let's say it's the pharmaceutical industry. So you probably want an arbitrator that has experience in pharmaceutical disputes. So, and you point someone, and perhaps that person also happens to be a pharmaceutical lawyer. So is that going to, that's double hatting, is that good? But again, if they're not the same parties, that's probably the most important one. And there's no, IBA red list, green list, or a red list or orange list issue, then you're probably going to be okay. You probably don't have to worry. And of course, that person should not have accepted the case if there was like a red list, or they should have disclosed and gotten party consent, or party did not object. So I don't think you should just be worried in your case. If it's just a similar case and it's a similar industry, I don't think you should be so worried, as long as the parties are different and there's no other kind of apparent possible conflict or issue. Just because it's a similar case probably will not be something that would merit challenge. Let's see. I think I've touched upon most of the questions, unless I've missed anything. Yeah, okay. I don't know. I think I've tried to deal with most of the questions. Let's see. I'm not sure if I missed anything. There's another question from Nak An Bui. The way I see an arbitration community is Vietnam is very small with few key players. Against boycott double hatting in the current context will exhaust the choice of Vietnamese arbitrators and discourage the increase of Vietnamese pursuing to become professional arbitrators. The IBA guidelines do not prohibit this practice, and there already is a duty of disclosure and also procedure for challenging VIAC. These tools could well supervise any conflict. I think the people are overcomplicating a simple issue. I think that's a fair assessment. Like I said, in commercial arbitration, once you clear the IBA hurdles and conflicts and disclosure obligations, you're probably okay. It's more in, and that's of course for the narrow definition of double hatting. And like I said, the broader the definition is, the more it kind of overlaps with the IBA guideline issues, conflicts under there. But the narrower it is, it's not really going to be covered explicitly under the IBA guidelines. Then it's more kind of the issue conflict stuff that comes up in investment arbitration and other areas. So for general commercial arbitration, I think Nok An Bui's assessment is probably fair. It's overcomplicating a simple issue. Once you clear those other big hurdles, though, yeah. Okay, unless there are any final comments from Dr. Liu. You're on mute.
Dr. Lynette, you're on mute.
I think he suggested that he has no comment, Professor.
Okay, all right. Ms. Dao?
So Professor, may I ask you for one more question from that we have from a law student?
Sure.
Yeah, he's with us on Facebook, and he's a law. So I like to read the question. So I'm a law student. I know that Yonsei University is among the top 3 universities in Korea. May I ask about any scholarship programs for Vietnamese law students at Yonsei University that you would recommend? Could you please share about the eligibility to enroll to the university? Yeah, it's very intriguing. Yeah, so.
Sure. We welcome, of course, brilliant, smart, hardworking Vietnamese students. And there are, of course, many, and I've had several former Vietnamese students. The best scholarship is the one given by the Korean government. And I'm sure you can quickly go Google it, but that's the best way to come to Korea. It's competitive, but most of my former students at Yonsei have come through that scholarship, the Korean government scholarship for students. Again, you can come and welcome to study. However, the other complication is if you study law in Korea, so there are 2 tracks to study. One is kind of our professional law school track, which is very, very difficult to get into unless you're very, very fluent in Korean as well. And the other track is kind of a general, more master's or PhD track. And that's where most of the students, almost all the students I've had from Vietnam come from. But if you go through this track, you do not become a licensed attorney in Korea, though. So that's the downside. But you will learn a lot, and you'll get well trained. So you should keep that in mind.
Thank you, sir. Thank you, Professor. So, so on behalf of the organizer from VIAC, I'd like to provide you with some statistic of the event. We have been served over 220 guests in this afternoon. And at this moment, there's still over 60 guests with us now. And we have received over 10, I'm roughly 11 or 12 questions, and all the experts have just answer or respond to the questions and the comments. And I understand that the double hatting issues is quite complicated and sometimes varies from jurisdiction to jurisdiction. We understand that in order to employ the good side of double hatting, and to avoid the bad side of double hatting, we need skills, we need experience. And we hope that from the practice that VIAC have from its actual cases at Vietnam, and also from the knowledge and experience of the VIAC listed arbitrator as Professor Kim, we could have to provide the community in Vietnam with those knowledge. And so in order to promote the arbitration practitioner in Vietnam. And once again, thank you so much for your time, Professor Dr. Lynette. Again, I'd like to invite you to the next webinar in the VAS series in the same time frame. I mean, next Thursday, we will look at the inside of the deliberation and the drafting award by the tribunal with some practical notes for the counsels. And the event will be in Vietnamese for the broader, audience. Once again, thank you so much. And I'd like to, you will have a wave to all the audience. And I hope to see you all very soon. Okay, so thank you.
Thank you.
Goodbye.
Yeah. Thank you very much, Professor Kim and the audience. It's our pleasure and honor. Thank you.
Great pleasure and honor, and wish you much success, and hope to see you in Korea.
Thank you.
And hope to see you in Vietnam.
Hope to see you in Vietnam, Professor, especially in the course, many courses of VAC. Thank you, sir. Goodbye.
Thank you. Bye-bye.